A very good evening and a warm welcome to PW OnlyIAS English channel. Continuing with the Udaan series for Prelims 2025, today we'll study Fundamental Rights Part 2. As you all know that this topic is quite long and analytical, and the questions in Prelims across the years have been very analytical. So I'll make sure that I decode every aspect of these fundamental rights, and today's agenda covers the articles from 17 onwards. Article 16, 17, today we are going to study these rights. Then we'll make sure that all these rights, including the writs, including Article 31A, B and C, 9th schedule to the Constitution of India, everything is dealt with in this lecture itself today. So let's begin the journey. As you all know that PDF can be downloaded from the Telegram channel, the link of which is given in the description box of this video itself. Now, yesterday, a quick recap, we had covered what is the meaning of Article 12, Article 13, Article 14. In the broadest sense, equality before law, equal protection of laws, all these things were covered. What is the difference between fundamental right, constitutional right and a legal right? So, writ jurisdiction of the Supreme Court, we had a brief idea as to for what rights, for the violation of which rights can you go to the Supreme Court and for which rights can you go to the High Court. The writ jurisdiction of the High Courts being wider than that of the Supreme Court. Now, moving further in today's lecture, we are going to talk about Article 16. We had studied Article 15 yesterday. Doctrine of eclipse also was covered as to what type of laws would be considered to be violative and would be eclipsed, so as to make sure that fundamental rights blossom in the right earnest. They are allowed to prosper, their fundamental rights are allowed to prosper, to be enjoyed, not to be overshadowed by the archaic laws of the British era and religious customs of ancient India and the present time laws by the Parliament of India, be it Aadhaar Act. Now, Article 14 we had seen being human and human beings example, petty human beings, if they are somewhere at a disadvantageous position, then the law should take such a course that these petty human beings are held to be equal when it comes to ensuring justice in the parlance of our fundamental rights. Now, moving further, Article 15 we had covered. What are the various aspects of Article 15? We had underlined the lines, the particular keywords that are to be focused upon when you set out to prepare for prelims. Had it been, if it were for mains, you could have simply read the line and understood its meaning. But you have to be very pricky, very nitpicky when it comes to observing these keywords in the PPT slides. So PPT slides will be shared. Some of them are not being shared for obvious reasons that these are the slides which we are going to use for Titan batch also. Okay, some of them are mains oriented. So we are revamping them or reorienting them in a manner that they cater to your prelims requirement. So some of the slides, some of the PPTs which have not been shared will be shared in due course of time. I'm editing them so as to suit the requirement for prelims. Now, Article 16. We had covered Article 15 yesterday. Now coming to Article 16. Equality of opportunity in the matters of public employment. So nobody should be at a disadvantageous position when it comes to availing or applying for any government job, be it of state government or central government, be it of union government or the federations. But domiciliary requirement, domicile requirement with regard to certain positions in the erstwhile combined state of Andhra Pradesh are theirs nonetheless. Okay, so they are there, just sons of soil theory exception is still there. We'll read them line by line. There shall be equality of opportunity. There shall be equality of opportunity in the matters of public employment for all the citizens. Okay, so Article 15, 16, 19, 29 and 30 are available to citizens only. Okay, so any office under the state, equality of opportunity has to be there. Now, no citizen shall, on the grounds only of religion, race, caste, sex, descent, or place of birth. What do we mean by descent? A person who is the descendant of Raja, a person who is the descendant of Gandhi family, a person who is the son of IAS officer will become IAS officer. These type of discrimination, there is no scope for this type of a discrimination when it comes to public office. Okay, no dynastic politics politics could be there, but no dynastic elements in the public offices. So that is the norm as per Article 16. Okay. Or criteria for residence. Nobody should be liable, nobody should be held ineligible or should be discriminated against in respect of any employment or office under the state. Now here the word language is not mentioned. Okay, can the language be made a criteria when you apply for, let's say, Punjab PCS, let's say Tamil Nadu PCS? Can Madrasi language, can Telugu language in Andhra Pradesh, okay, be made a feature? Can be made a compulsory element? Yes, because language, having studied or having the ability to study a particular language, gives you the administrative efficiency to understand the problems of the local people. So the word language is not mentioned here. That means any state government, any state legislative assembly can enact, can put language as a criteria, as a compulsory criteria, can discriminate against the known locals when it comes to applying the job in the state government, state PCS. When you write the exam for SDM, etc., language could be made a compulsory criteria, that you should have studied Punjabi in the 10th standard in the matriculation exam when you apply for Punjab PCS. But as per the judgments of Punjab and Haryana High Court and Supreme Court, if a person has not studied Punjabi at 10th standard level, but he can later on be trained in Punjabi, he appears later on in the qualifying exam and he clears the exam, then this language cannot be the criteria to discriminate against outsiders. Okay, so this kind of a pattern has evolved now. We are turning into, gradually we are turning into a mature democracy, maturity of rule of law. So refinements are happening in the judgments, through the judgments of the court. Now Article 16 clause 3, nothing in this article shall prevent the Parliament of India from making any law which prescribes reservation of certain classes of employment for local, for the employees of the state, for the people who are domiciled in the state or union territory. Such a law which creates discrimination on the basis of domicile of the people can be enacted by Parliament only. Such law was enacted for Telangana region of Andhra Pradesh in the before the partition of Telangana. That law has been in existence, that only the people of Telangana region which were getting relegated, which were getting, their condition was deteriorating insofar as their representation in the public offices, government offices was concerned. That is why Parliament of India alone can create. Okay. Clause 4 says that nothing in this article shall prevent the state from making any provision for the reservation of appointment or posts in favor of any backward classes of citizens, which in the opinion of state is not adequately represented in the services. Okay. So again, state can make any provision for the reservation of appointments in favor of any backward classes. So even the state government through the governor's list can come up for reservation for certain backward classes. Union government releases its own list. That list is issued by the President of India on the aid and advice of the President, the Council of Ministers, as per Article 74. Here we are talking about the governor issuing a list of OBCs insofar as employment to the state services is concerned. If any vacancy arises in the state government, the list of backward classes as issued by the state government will be referred, will be followed by the State Public Service Commission while filling up the employment posts in that state. That means both the center and the state can have their respective lists insofar as filling up the vacancies, filling up of the vacancies at the respective levels is concerned. Am I clear? Okay, so state can make, even though there will be a general equality, a sense of equality will prevail in the matters of public employment, but special reservation provisions can be carved out for people, for sections of society who have relatively been relegated, who have been given, who have been kept at a disadvantageous position in the old India. Okay, pre-independence India, ancient India, Varna system, those kind of things. So as to ameliorate them, so as to uplift their condition, ameliorate their condition. Fifth, nothing in this article shall affect the operation of any law, which provides that the incumbent of an office in connection with the affairs of any religious or any such body, denominational institution, or any member of the governing body of the temple, religious institution, be it masjid, shall be a person professing a particular religion. Again, Article 16 says that even though there will be a general equality, barring domiciliary requirement, barring OBC or backward sections of citizens, the classes requirement, Article 340, Article 342, SC, ST, OBC reservation. Fifth one says that, understand it this way, in Punjab, Golden Temple, okay, SGPC elections are held. When the SGPC elections are held, as per the SGPC Act 1925, if I'm able to recollect the act correctly, it is of 1925 or 1920. Anybody, Britishers wanted to have some semblance of control over the religious institutions because they realized that religions play a very important role in the lives of Indians. So they wanted to control religions, even though not the strict sense of control, but yes, a semblance of control, a feeling like control. What they did is, whenever the Shiromani Gurdwara Prabandhak Committee, Management Committee elections will be held, district collector belonging to the Britishers would head that committee, the election supervision, etc. Okay, so even to this day, district collector chairs that meeting in his ceremonial capacity. Elections are conducted by SGPC. Government has no role in conduct of elections whatsoever. But only thing that Sikhs have kept as a condition, Sikh community has kept as a condition, is the person who will be the DM at the time of supervising the elections or chairing the meeting, of first meeting of SGPC, he should be a Sikh. He should be a member of Sikh community wearing turban. So what happens is, this article in a way allows for such kind of exemptions, that if there is Tirumala temple committee, okay, anybody who belongs to that religion should only be heading that committee in the even if in the ceremonial capacity. Now there are certain temples, certain religious institutions whose salary to an extent is borne by the government, even though government appoints them. But if it is a Muslim community body or if it is a Hindu community body, the salary would be paid by the government, but the member of that employment, the person gaining that employment, should belong to that particular religion. This is what this article is saying, that even though there will be general equality, but anything given in this Article 16 shall not prevent the religious denomination, the religious body, from having its people belonging to its own religion to manage the affairs, even though government is regulating it. Example, SGPC, Tirumala temple, okay, Bhubaneswar temples are there, religious institutions are there. So their provision for persons belonging to a particular religion to manage, to head that affairs of that agency are already taken care of. Now, I told you generality, equality is there. Had it been, if it were American Constitution, only Article 14 would have been enough, because it is the general expression of right to equality, right? But as we go deeper, Article 15, prohibition of discrimination in general in society. Article 16, prohibition of discrimination in employment. This is societal discrimination, Article 15. This is the broadest sense of equality. So Article 14, 15, 16 talk like this. These are permeable circles with Article 14, the mandate of Article 14, a facet of Article 14 being provided by Article 15. Another facet, that is equality in matters of public employment, being fulfilled by Article 16. Okay. So general understanding, Article 16 clause 1 and 2 give a general rule that there shall be equality of opportunity for all the citizens in the government jobs. However, Article 16 3, 4, 4A, 4B provide further strength to all sorts of discrimination among the people on the account of their unequal status. So Article 16, Article 15, they take into account that there has been a general sense of inequality in the society, in the public employment, that needs to be eradicated. Then only historical injustice would be neutralized. That is why these provisions 16.3, 4.4a, 4b are important. Now 16.4 allows the state to make reservation for any backward classes. 16.4a empowered the state to make reservation in promotions also for SCs and STs. We'll talk about M. Nagaraja judgment when we'll talk about the full-fledged classes of Indian polity. Okay, 16.4a, for now you remember this. Okay, now why this one is in blue? Reservation is not a matter of right. This is what the Supreme Court had said. Now moving further, this is again mains oriented. Ram Singh versus Union of India, popularly known as Jat reservation case. In this case, the Supreme Court said that nobody should, state should go beyond the caste as a criteria for reservation and look for economically weaker section as the criteria or any such criteria. Okay, but going beyond the idea of just the caste, as caste based reservation has been equally divisive in terms of societal egalitarianism, okay, fraternity. So this caste based reservation should be in a way discarded by the government, and government should rise above the caste based politics, and they should think of reservation on some other lines: transgenders, disabled people, economically weaker section, etc. Okay, now this is there. Article 338A, National Commission for Backward Classes was created. It was given a constitutional status by the recent amendment. Okay, Article 338B was added to the constitution. So National Commission for Backward Classes, National Commission for Scheduled Classes, and National Commission for Scheduled Tribes was already there. Initially there was a combined commission, National Commission for the scheduled classes and scheduled tribes. Later on it was amended. Article 89, the 89th Constitutional Amendment Act added Article 338, which divided the special officer for scheduled castes and scheduled tribes into two, which was 338 dealt with National Commission for Scheduled Caste, 338A National Commission for Scheduled Tribes, because seeming the looking at the injustices meted out to scheduled castes, they cannot be clubbed up with the scheduled tribes. So it was thought right, wide 89th Constitutional Amendment Act, that the injustices, the victimization that SCs are subject to, scheduled castes are subject to, are different from the victimization and injustices to which scheduled tribes are subjected to. That is why the officer looking after these two separate set of the classes or castes in society should be different. Two communities in society should be different. Later on, now a new body has been created under Article 338B by enacting a new article, inserting a new article in the Constitution, 338B. This body earlier was a statutory commission. Now the statutory commission, National Commission for Backward Classes, has been given the constitutional status wide Article 338B. Okay, National Commission for Backward Classes has been created. Okay, wide Constitutional Amendment Bill 123. Okay, so 104th Constitutional Amendment Act it is. Moving further, okay, so this is there. This is of relevance. Read Article 340 also, because there was a criticism that Article 338B, which talks about scheduled castes and scheduled tribes, how can a branch of Article 338 be carved out to give protection to OBCs or SEBCs, socially and educationally backward classes? Logically, Article 340, which deals with the matters of OBCs or socially and educationally backward classes, should have been used by the government to create or to give constitutional status to National Commission for Backward Classes. Okay, but the government used an article which was meant for the protection of scheduled castes and scheduled tribes. What difference would it bring? What is the difference? It is just an article number. No, it is like expecting mangoes from a banyan tree. When an article which is meant for the protection of SCs and STs, constitution makers would have kept it separately from Article 340, because the victimization, the historical injustice, the seclusion to which SCs and STs are subjected to, they are the victims at the hands of OBCs in certain cases. So when in the future, maybe 30 years, 3 decades, 4 decades down the line, this interpretation challenge could come before the court as to why the parliament enacted 338B. They could have instead kept the matters of OBCs under 340, not giving as much protection to OBCs as was given by the constitution makers to scheduled castes and scheduled tribes. Okay, so this is there. This is a bit tricky. That is why I said someday we will deal with it in the daily news analysis or in some other lecture. Now, abolition of untouchability. These historic ignominious practices still continued. They were even prevalent at the time of independence. So that is why a specific article, which is another facet of Article 14, equality, if there would be no untouchability, there would be equality only. But that is why Indian Constitution is considered to be very detailed. Now, untouchability has not been defined in the Constitution. Just for your prelims, for the material, I mean, food for thought, just note it down. Okay, but what are the contemporary, even though the practice of untouchability is not practiced as much, but what are the other facets of untouchability? Leprosy, skin diseases. Okay, so people keep off, they maintain distance thanks to the contemporary phenomena like COVID, etc. These facets are being used to keep away people belonging to, or people who not wearing such good clothes or wearing shoddy clothes. They are kept off, they are kept away. Okay, snobbish value of elitism, snobbish value is visible. So these are again main point of things. Just note down, Article 17 is another facet of Article 14 only. Moving further, abolition of untouchability. Untouchability is abolished and its practice in any form is forbidden. Analysis, legislative enactments related to Article 17, this Untouchability Offences Act 1955. This act was renamed in 1976 as Protection of Civil Liberties Act. Why? Because the mere naming of the act, Untouchability Offences Act, was itself in a way propagating untouchability. If not preaching, at least propagating. That is why a neutral term, Protection of Civil Rights Act 1976, was adopted instead of Untouchability Offences Act. Okay, so whatever is open to general public should be open to the members of scheduled castes also, because scheduled castes have been the victims of this untouchability the most. That is why. Now, general meaning, etc., manual scavenging, these are the other facets. AIDS, leprosy. That is why HIV and AIDS Prevention and Control Act 2017 prohibited the practice of untouchability or discrimination against HIV affected patients also. Okay, since HIV does not spread by a mere touch, unless of course there is a sexual activity. Okay, so anybody preaching or anybody meting out the practice of untouchability towards HIV patients would also be held liable now under HIV Prevention and Control Act 2017. Okay, now these things are there, but mains oriented, when I will do this analysis, on one hand we are saying that untouchability practice has been abolished or it has been criminalized, but on the other hand, state of India, included state governments and government of India, are still constructing, they had been constructing dry toilets under Swachh Bharat mission. They were leading to a practice where people belonging to the lowest rungs of society, they have to pick up the human excreta with their own hands. Now the other people who are not into this job, they will have to keep themselves at a distance so as to not let them be the victims of diarrhea, etc., by coming into touch with such people. So why manual scavenging practice still is in practice? Why dry toilets, which create a germane condition for manual scavenging to be practiced, are still being constructed under Swachh Bharat mission, right? So this kind of an analysis you can pull out from the newspaper reading. Article 18, abolition of titles. No title, not being a military or academic distinction, shall be conferred by the state. No citizen of India shall accept any title from any foreign state. Okay. That means the independent India, we said that these kind of titles which confer some extra privileges, hereditary titles, they are completely forbidden. Even if somebody is given an accolade by Defense Ministry, Bharat Ratna, etc., they should not use these as the prefixes or suffixes before and after their name. Okay, so fixing them up as the prefix or suffix will tantamount to misusing them, and they might be snatched from the person. The government of India might take them back if somebody is found misusing or fixing Bharat Ratna above, I mean, before or after their name. Okay, so 18.2, no citizen of India shall accept any title from any foreign state. For example, if Shashi Tharoor goes to UK and starts speaking swanky panky English, fluent English, he starts and he gets the Queen Elizabeth some medal or some accolade, and he starts using it without the permission of the President of India. Accepting any such foreign title or any such honorary title or any such award will tantamount to a criminal thing, or might lead to that person being declared as a non-citizen also in the extreme cases. Okay, so foreign titles are not allowed, but accepting the accolades from the United Nations or from other countries with the permission of government of India is allowed. Okay, then no person who is not a citizen of India shall, while he holds any office of profit or trust under the state, shall accept without the consent of the president. Here, the consent of the president is important. Here, even with the consent also, in ordinary circumstances, you should not accept. Anybody who is a citizen of India, completely prohibited from accepting any foreign title. Here, anybody who is a citizen of a foreign state who is not a citizen of India under Article 18 Clause 3, while he holds any office of profit. See, this was basically for people who were who were the members of Indian civil services. When India got independence, right after India's independence, our first Home Minister, Sardar Vallabhbhai Patel, he wanted members of ICS to continue to stay back in India so that they can pass on the administrative skills, the legacy, the understanding of the Indian administration to the new buddies, to the newbies who were getting selected to IAS. That is why, if during their stay, the ICS officers who were originally the members of the British, citizens of the Britain, if they are staying back in India, they cannot accept any award from Queen Elizabeth or British Prime Minister without the consent of the President of India during that time, era of 1950s to 1960s. Got it? Now, Anglo Indians, Article 331 allowed two Anglo Indians to be appointed to Lok Sabha. This provision was there until 2017, 18, 19, 18, 19, 19, right? Article 331 has now been abolished. It has been repealed now. There would be no reservation for Anglo Indians in the Lok Sabha anymore. But imagine till the time they were there, okay, Anglo Indians, if while they stay in India, while represented, while being MPs of Lok Sabha, if they are accepting any kind of foreign title or award, does it not tantamount to conflict of interest? That is why no person who is not a citizen of India, while he holds any office of profit or trust under the state, shall accept. Even though I've just given you the example, anybody cannot be the member of Lok Sabha until and unless he is a citizen of India. Okay, but just imagine through these examples, try to understand what I'm trying to say. Article 18 Clause 4, no person holding any office of profit or trust under the state shall, without the consent of President, accept any present, emolument or office of any kind from or under any foreign state. Again, anybody who served in the US, United Nations, who served in the United Nations, or as a judge of the International Court of Justice, International Criminal Court, okay, any international body, WTO, WHO, no person holding any office of profit, not only citizen, any person holding any office of profit under the state shall, without the consent of the president, accept any president any present emolument or office of any kind from or under any foreign state. Okay, even though that person who is representing India at the United Nations, even though he is not a citizen of India, but he's been hired as a lawyer or as a judicial tribunal member in the Indus Water Commission, Permanent Commission of Indus Water Treaty, okay, any such capacity, neutral arbiter, etc. Anybody who is holding any office of profit, deriving any salary, pension from Government of India, from the State of India, shall not accept any present emolument, pension, etc. from any foreign state. Now, academic title means the titles like doctor, IAS, etc. Only these type of academic titles are allowed. These are not titles in the strict sense of the term. Okay, they cannot be used to flaunt. IAS is written at the back because it shows that a member belongs to IAS. Okay, CA, academic distinction allowed. Doctor, academic distinction allowed. MBBS allowed. It prohibits a citizen of India from accepting any title from any foreign state. This is the explanation to these complex articles as they are taken from the Constitution of India, the Bayer Act. Okay, now a foreigner holding any office of profit or trust under the state cannot accept any title from any foreign state. Example, salary to Indian diplomats retired from UN, WTO, IMF is allowed, but with permission, guys. Okay, I'm being a little fast, taking no breath in between, giving you no sigh of relief in between, because we have to complete this topic today. So, which is the article which is applicable to foreigners? Article 18. If they are serving in India, or if they are serving India's interest abroad, or if they are deriving any office of profit from the Indian state, right? Some chartered accountants, they are appointed on the payroll of India. They are taking some money from the consolidated fund of India, but they are representing India's cause abroad. Even though they are foreigners, but they should not accept any kind of foreign title, etc. No hereditary titles of nobility, because they also create a sense of inequality. Diwane Diwan, Diwane Khas, okay, Shero, these type of titles conferred by Mughals, those type of things are not to be used. Okay, Shahi Diwan, etc. are not to be used. Now, this is exceptions. Again, the analysis part of it, we'll skip out on this. Now, coming to another interesting article, Article 19. Six rights, Article 19, Clause 1, subclause. This is Article 19, Clause 1. Okay, it guarantees 6 fundamental rights. Earlier, there were 7. Sixth one got deleted. Right to property got deleted. So, I will explain you the sequence in a funny manner that you'll never forget it. Shall we? See, Article 19, Clause 1 says that you have freedom of right to speech and expression. You can express yourself. You have right to freedom of speech. It is your right to freely express yourself via speech or via expression. Angry, funny, laughing, mocking, anything. Smile, anything. Okay. Right to freedom of speech and expression. Then, right to assemble peaceably and without arms. You can assemble at any place peacefully, Kumbh Mela, etc. And but you should not be carrying any arms or grenades or ammunitions. Done. C. Right to form associations or unions. You can form an NGO. You can form. You can start your own ashram. You can be a Baba. No one is stopping you. You can form your political party like Kejriwal. No one is stopping you. Right? So understand the magnitude of my examples. Though there is stopping you, that we will deal with in the democracy at work section of our Indian polity. But right now we are preparing for prelims, a revision series, a little bit of jokes here and there. Associations or cooperative societies, you can even form a company, you can even form a partnership firm. When we talk about the commerce side of it, when we talk about the political side of it, you can form the religious side of it, religious association, ashram. You can be the next Ram, Asaram, Gurmeet Ram, Ram, anything. Okay. Now, right to move freely throughout the territory of India. You can move around freely throughout the territory of India, but not the tribal areas, Schedule 5, Schedule 6 areas. Okay, there you cannot go because you will then be disturbing the rights of those tribals. Exceptions are there. We'll talk about those exceptions in a short while. From now, right to reside and settle in any part of the territory. You can reside anywhere you like. Again, exceptions are tribal areas. You cannot go and say that I want to reside only in Manipur where inner line permit is applicable. Thereby, you will then be disturbing the demographic equilibrium of that area. Influx of population into tribal areas will disturb their inherent or natural way of life. Then, right to practice any profession, carry out any business, etc. Very theoretical, no? Let's study them in a funny manner so that you never tend to forget them. First, clause 1, subclause A. Imagine you are in the college age, first year. You can freely express. So this is a funny side. Anybody from the PW team might be checking it. Please don't frown upon it. This is just a funny trick to help these kids, the children preparing for UPSC to memorize this. You are in the college, you propose a girl or a boy, you have a freedom of speech and expression. You can express yourself freely. You can take a bouquet of flowers, red rose, anything, or blink of an eye, anything that suits you. Freedom of speech and expression in the college freshers party. Second, you call her or him on date. On the first meeting, you can assemble peaceably without arms. Getting my point? Those arms, keep aside. You should not, in the very first meeting, try to bump into that girl or boy peaceably and without arms. Then, after a while, as the love blossoms, you will form association of marriage, nikah, or anything, right? So, right to form association or unions, union for life, love marriage, or cooperative, anything cooperation, anything co-parenting, whatever you live, not live in. Okay, we're talking about marriage only. So, right to move. After that, you will go for a honeymoon. Right to move freely throughout the territory of India. Only territory of India. Why not Thailand? Why not Dubai? Because you might have gone against your parents. Love marriage might have been against the wish of your parents. So, no money, no honey, right? No honeymoon, that kind of foreign honeymoon, only local. You'll take her to Simla, etc., like that. Now, right to move freely throughout the territory of India. Then, after having gone for honeymoon, everything, you will reside somewhere. You'll have to earn, fend for herself and for yourself. Right to reside and settle in any part of the territory of India. Right to property, since you did the blunder of love marriage, your parents will not give you any property. Right to property, gone. You don't have any right. Now, you will have to practice anything. Right to practice any profession or to carry out any trade, any occupation, any business, be it of teaching or anything like that, so as to earn for yourself and for herself. I hope looking at these, just if you remember, right to freedom of speech and expression, right to assemble peaceably, right to form union, that is marriage, then you will take her to honeymoon, right to move around through the territory of India, then reside and settle down somewhere. Okay, then property, you won't get any property. Right to property is abolished for you. Okay, then right to practice any profession, you have to earn money at least to fend for yourself. Okay, now this is how we can memorize. Clause 2, so this is clause 1. Again, I'm reiterating 19 clause 1, A, B, C, D, E. F has been deleted. Okay, so coming here, clause 2, nothing in subclause A of clause 1. That means freedom of speech and expression. Nothing in this shall prevent the state. State, if it wants, can regulate your freedom of speech and expression to the extent that, insofar as complicated words, to the extent that state wants to impose reasonable restrictions on, nation wants to know, so that he is not instigating India's neighboring countries against India. Sovereignty and integrity of India, nobody should start foisting Khalistani flag. Sovereignty and integrity. India, Akhand Bharat, unbreakable, okay, indestructible union. Freedom of speech and expression is there, but you should not start any separatist movement. Otherwise, like Hasina Mufti, Mehbooba Mufti, you will be lodged in jail under Public Safety Act of Jammu and Kashmir, right? Mehbooba Mufti was lodged. This is how you can remember things in a funny manner, not to take too much of stress in life. Already there is a lot when you are preparing for UPSC. Now, security of state. For the security of state, again, your freedom of speech and expression needs to be curtailed sometimes. You want to go to, for example, somebody wants to uh, sit on a fast unto death to instigate his community against the government of India, to create some illegal association, maybe by asking others through the freedom of speech to come and join him or her. No. Okay. Friendly relations with foreign states. Some news anchors, as I named a few, what do is they run a hate shop all the time on their TV channel. They are instigating neighboring countries of India. Pakistan should be killed, Pakistan this and that. If they happen to harm the relations of India with foreign states, including China, then their freedom of speech and expression can be curtailed. Last but not the least, POMH. Okay, PODM, sorry. MH we'll talk about later on, okay? Public order, decency, or morality. By instigating others to commit some crime. There are some songs in Punjabi which have been censored by the Supreme Court also. Honey Singh songs castigating women or showing women in the negative light. Okay, or some songs like Chaklo Revolver by a Punjabi singer. Pick up the revolver and we have to take revenge. Somebody picked up the revolver and shot the other farmer with whom he had the land dispute. Such kind of instigating remarks in songs, in movies could be curtailed under public order. That is how state governments, that is how Central Film Certification Board, under the garb of public order, has been censoring movies, which is not wrong many a times, but sometimes it fringes on the border or even exceeds the borderline. Decency. M.F. Hussain started painting the nude paintings of Indian deities. Morality, decency. You should not, in India, there is no culture of porn stars. You should not start any nude dance. Otherwise, you will be booked for indecency in the public realm. You should not kiss someone while flying in the public transport. Decency, morality. You say, I'm expressing my love, but it is affecting somebody else's ride, travel, right? So, those kind of things should be avoided in the public domain. Public order, decency, morality. PODM. Got it? Restrictions on now. Each of these clauses, clause 2, 3, 4, 5, 6, they cater to A, B, C, D, E. One by one. Clause 3, restrictions on right to assemble peaceably and without arms. There are only two grounds on which the state of India can restrict these: sovereignty and integrity and public order. Okay. So, sovereignty and integrity of India, if you want to create some organization which is antithetical to the idea of security of India, Unlawful Activities Prevention Act would be applied. Right? Two grounds: sovereignty and integrity of India, you are trying to harm. So that is why National Socialist Council of Nagaland, that is how they have been banned by the government. And public order. Again, arms and ammunitions, etc., should not be carried. Again, public order, any such association that you form should comply with FRBM Act. You are not instigating protests around Kudankulam nuclear reactor, etc. Even if you are an NGO named Greenpeace, but if you are spreading some violence, your name is Green Violence. Again, the FRBM Act license would be suspended. NGO would be banned forever. Okay. Clause 4 caters to restriction on the right to form associations. That is Article 19, Clause 1, Subclause C. Here, sovereignty and integrity of India and public order and morality. Sovereignty and integrity of India, one, and public order and morality also. Association that you form, okay, it should be moral. It should not be an association for cow slaughter, for example, if it is illegal. It should not be an association for making pornographic videos. Any association. If you are living in live-in relationships and government wants you to register them morality angle will be applied. Okay, public order is already there. Associations should not be antithetical to idea of public order, right? I'll tell you. One, we've told you the movies, they have to be decent in character. If any Gadar movie is also being made, it should not be instigating the any section of society, instigating any of the sections of society, be it Muslims or Hindus. If some movie like Padmavat is being made, it should not show Rajputs in negative light, instigating them to rise up in arms against the state. Okay, oh my God, movie. Three Idiots, not Three Idiots, your PK movie. Anything which disturbs the society and disturbs the public order can be the ground for censoring such movie, censoring such TV show, or curtailing such activity. Then restrictions on freedom to move freely in the interest of general public and scheduled tribes. Now, freedom to move freely is there, but in the light of stampede in Allahabad, Prayagraj, thanks to Mahakumbh, okay, Mauni Amavasya rush that was there, can the right to go to Prayagraj, can all the flights to Prayagraj and trains inwards to Prayagraj, can they be cancelled? Yes, because general public, in the interest of general public. When you go to religious shrines like Jammu, Vaishno Devi temple, there is a ticketing system, ticket. When you are climbing up the mountain, the hill, okay, n number of people only can be handled by that temple shrine board. That is why without ticket they don't let you go. And tickets are issued only when the people are there in the numbers which can be handled by that shrine. Beyond that, it might lead to stampede or landslide or any kind of rumor of stampede and would lead to some tragedy. Public interest. If you are carrying out any Rath Yatra or any Yatra or any procession, religious procession, peaceful procession, you have to take police permission. Then what police does is, two sepoys, two constables, 10 constables would be walking besides with a thick rope so that the free movement of traffic on the other side of the road could be maintained. So these are the restrictions on the freedom to move freely. I'm giving you very common examples so that you can memorize the restrictions. Restriction on freedom of profession. Herein comes public order, morality, and health. Okay, it's not mentioned here. Professional or technical qualifications will be required. Okay, so any quack, any doctor who's gained some diploma degree in Ayush medicine, and he opens a clinic for modern medicine allopathy, he would need professional or technical qualification. You cannot say that I'm a Baba or Godman who's been blessed with supernatural powers to cure all your problems. Technical qualification to practice that profession is required. Originally, Article 19 contained 7 rights, but the right to acquire, hold, and dispose of property was deleted by 44th Amendment Act. Now, how to remember? Many people get confused between 44th Amendment Act and 46th Amendment Act. See, even though it was the 42nd Amendment Act which did a lot of damage to the Constitution, but the real blow, the deleting of fundamental right, repealing of, fundamental right was brought about by the amendment that was brought about by not the Indira Gandhi government, not the government which brought about emergency, the next government. Okay, 44th Amendment Act. Got it? 42nd Amendment Act damaged the basic structure, etc. But right to property was deleted by none other than 44th Amendment Act. Okay, and it added a legal right. Now, salient points to note, all of them are positive rights. 19 clause 1, A, B, C, D, E. They are enabling and empowering in nature. While if you see Article 15, 16, 17, they are negative in connotation. What do we mean by negative in connotation? Negative in connotation means that they take away more than what they give to you. Sometimes, okay, prohibition, prohibition, prohibition. Sometimes they are curtailing the other citizens' right to let the other section of citizens enjoy that right. To let the disprivileged sections of society enjoy the right, they are curtailing the rights of the privileged sections of society. general versus non-general population. Okay, but all these rights under Article 19 are highly positive in nature. They are enablers. They are not imposing any kind of disablement. Yes, of course, some exceptions have to be there. Okay, so these are the mains oriented questions. We are not going to go into them as of now. Okay, Sham Benegal Committee, again, Cinematography Act. Very soon, I'm going to take classes from 3rd February onwards for Indian Polity under the Titan batch, English medium batch. So there you can find this content. Okay, we'll be dealing with this. These PPTs are also being updated simultaneously, parallelly. So we'll see more on this in the coming days. Okay, now right to freedom of speech and expression, right to propagate one's views as well as the views of others, freedom of the press, freedom of commercial advertisement, etc. Now, these just read them, guys. This will help you a lot in answering the questions which are framed around in prelims, also answering those questions which are framed around the practical relevance, the examples that we see in the newspaper. Okay. Now, contemporary relevance, this is a right to profession is tempered by another citizen's right to good services. Quacks versus genuine doctors, etc. Then Article 20, self-incriminating evidence. Okay, conviction for offences. Very easy. No person shall be convicted of any offence for some law which has not been in, force yet. Okay, if you commit the crime on, let's say, 1st of January 2025, for that crime there was no punishment at that time, on that date. But on 5th of January, government enacts a law and says that the offense that you had committed is now punishable from the back date, retrospective date, retro date, back date by 3 years. This will be travesty of justice. Okay, this will be like jeopardizing you, in a way victimizing you. So that is why no person shall be convicted for any offense except for the violation of the law in force at the time of commission of the offense. This is applicable in the case of criminal law only. That is why in the matters of taxation we see that in the matters of taxation, what do we see? We see that civil law, matters of tax, GAR rules, general anti-avoidance rules. Okay, taxation, imposition of tax from the back date is applied, is applicable, is allowed. But making something which was a civil offense into a criminal offense after it has been committed. For example, if I accidentally jumped the red signal on 1st of January, for which there was just a fine of 1000 rupees. On 5th of January, I get a message on my phone that the law has been enacted to the effect that anybody who jumped red signal on 1st of January would be punishable with an imprisonment for 3 months. Criminal angle to it. Isn't it criminal? This cannot be done from the back date. But if the message or some Times of India notification comes on my phone that anybody who jumped red signal, for which earlier the fine was 500 rupees or 1000 rupees, has now been increased to 10,000 rupees, I will have to swallow that increased amount, because I cannot go to the court that, see, the amount of fine has been increased. But if a civic offense on the date of commission of the offense is converted later on into criminal offense after it has been committed, you can go to the court that, see, state is violating your Article 20. No person shall be convicted of any offense except for the violation of the law in force at the time of commission of offense. Clause 1, easy. Okay, no retrospective law, simple. But retrospective law in taxation is beyond the scope of Article 20. It is allowed, that means. No person shall be prosecuted and punished for the same offense more than once. Very easy. When in childhood you used to commit some blunder, you break a glass of water, glass or something, okay, you happen to scratch, put pencil scratches all around your house. How many slaps would you get on your cheeks? 1, 2, 3, 4. But you would have questioned your mother, I have done one mistake, I have broken just one glass, and why you have slapped me 6 times? That means that sense of justice prevailed upon us. It was there inherently in our mind that how could we be victimized for the glass that we broke the other day? Okay, for something that we did in ninth or 10th standard, when we scored less in 12th standard, our parents are again yelling at us, citing the marks of ninth standard, 10th standard. During ninth standard also you had scored low. That was childhood. Here in the Constitution of India, as adults, we should not be subjected to double jeopardy. Only one offense, one time punishment. Every time you cannot be haunted or rounded up by the police just because you committed the crime in the past. Got it? But imagine a god man raping 2 women. 10 years plus 10 years, 20 years. That is not double jeopardy. That is not twice the punishment. That is not subjecting the same person to punishment again and again. He is committed the crime again, compounding, clubbing up the tenure, the sentence term, 10 years plus 10 years will amount to 20 years. That is not beyond, that is not within the, double jeopardy means subjecting the same person to two times for the crime that he has committed only once. Okay, simple. Article 20 says that nobody should be condemned twice for the offense that he's done only once. But imagine a godman, there have been such godmen in our country, that is why I'm giving you the example, procuring drugs, consuming those drugs, and letting other women consume those drugs and then rape them. In the possession of the drugs, consumption of the drugs, intoxicating a woman, and raping a woman. 4 plus 5 plus Narcotics Act, all those sections, Criminal Act, CRPC, raping, intimidating or hurting the modesty of a woman, all those sections amounting to life imprisonment, 10 plus 10 plus 20, whatever, lifetime imprisonment, incarcerated for life. Why? Because he's committed multiple crimes, which in technical language are called predicate offense. An offense which precedes the ultimate offense, kidnapping a person and then killing him, looting him, picketing him. Two offenses: kidnap, then looting. Punishment for the two: 10 plus 4 or 4 plus 10, 14 years. But if the same person is said that you've committed the crime of um, kidnapping a person, so you will be given punishment 2 times. Wrong. That person can go to the Supreme Court or High Court saying that he is being victimized. Okay. No person accused of any offense shall be compelled to be witness against himself. Confess that you have committed the crime. That is what police does. Police, by meting out third degree torture onto a criminal, onto an accused, can make him confess that yes, he was the culprit. Because of the pressure on police, sometimes police happens to make the accused confess for anything that they haven't even done. That is why this self-incriminating evidence, sometimes UPSC is using technical words, so I'm telling you, self-incriminating evidence cannot be allowed to be used. Okay, getting my point? Self-incriminating evidence means uh, evidence against yourself. That is why there is separation between judiciary and executive. Why am I telling you this thing? Am I making your task tougher? No. Question can be framed in this manner: on what basis, which of the following articles talk about separation of judiciary from executive, or which of the in which of the following articles the separation from judiciary of executive is implied? Article 20 clause 3. Yes. The evidence given by the evidence given to the police, the confession given to the police has to be corroborated with proof, with case property in front of the judge. If in Arushi Hemraj murder case, a very popular sensationalized case in Noida, where a girl named Arushi was killed in suspicious circumstances, but the case hasn't been solved yet. Okay, Dr. Talwar and all. In Arushi Himraj murder case, it was alleged that the servant committed the crime. The judicial magistrate asked, did we find that knife, that uh, very big knife, in Nepali type of knife, which is called kukri? Okay, did we find that? Police said yes. Did we find his fingerprints? They said no. But my lord, he is confessed that he's committed the crime. Judicial judge said, sorry, but the evidence is not corroborating the statement given by the accused. So accused is let go. Accused is allowed to go. Okay. Accused should be allowed to go without any charge of offense on him. This is the meaning of Article 20. Okay. Now, an ex post facto law. Ex post facto law which happened ex, past the occurrence of, post means past, afterwards, the occurrence of the crime, occurrence of incident, shall be held to be invalid. Explanation, I think we've already covered it. Okay, now Article 21 is a longish article. We'll cover this in the next class. Rest of the articles, will be covered in the next class. Today I had a lot of other classes and sessions to be taken. We'll try to complete the fundamental rights in the next class. Whatever extra time we are taking in fundamental rights, trust me guys, it is worth the time, because a lot of questions are coming. If I would rush you through quickly through all these articles in a rushed manner, we are not doing justice with the revision. Trust me, sparing 1 hour is justified when you happen to attempt some questions of the fundamental rights given at the back of your book or previous year questions. I'm sure after having gone through this analysis, your attempt rate, your correct rate, the rate of correct questions would definitely go up. Okay, that is my assumption, based upon the efforts that we are putting in. So this was all for this lecture today. We'll see you again tomorrow under this awesome series, Udaan series for Prelims 2025. Based upon your request, we are also thinking of starting 2 lectures at a time under the Udaan series also. Okay, very soon you'll get to hear from us through the medium of YouTube channel or some update from the one or the other faculties or from my side itself. Thank you. Bye-bye. Have a great time ahead. Keep revising, keep fighting until you are on the other side of the fence, the Basana side. Thank you.